Hello everybody, Martin Radner here from Radner Law Group, bringing you trial analysis. It just doesn't end with the Melly case. Always something going on. A new filing today by the defense team. Actually, this was filed on November 1st, and it just doesn't stop. And this is actually a filing by the defense. And defense files, and this is the title of this motion, defendant's second motion to dismiss. So the defense is asking the judge to completely throw this case out. No second trial, no retrial. The case should completely be dismissed. And you'll recall that we spoke a little bit about in our previous videos on Melly about the initial motion that the defense filed to dismiss the case, and that was due to some prosecutorial misconduct. As we spoke about this whole situation with Detective Moretti trying to solicit a deputy to lie for him, and the fact that the prosecutor, Christian Bradley, did not file a Brady notice and turn it over to the defense and let them know about this, and they didn't know about this during the first trial. That all was filed already in an initial motion to dismiss, which the judge denied. The judge did not grant that motion, obviously, as the case is continuing to progress. Right now, we're in the middle of jury selection. However, the defense is right now asking, just stop everything, stop wasting everyone's time, send the entire jury pool home, because now we have another basis to dismiss this case. It's the second motion to dismiss, and we will jump into it in just 1 minute. Please, if you haven't yet, subscribe, like the video so we can continue growing and bringing more people this very important analysis. I don't know how many other people are going through the filings in this case, but it's just unbelievable, and it's important for everyone to be really well informed about these filings that are filed in this case. So what is the basis for this second motion? Obviously, the first motion got dismissed. The first motion for dismissal was not granted, was denied. So now, why should now the court now grant this motion? Well, there's been more revelations. There's more investigations and more revelations, and this is what the defense argues in this motion. So in addition, first of all, they say obviously everything that we've already mentioned in our first motion to dismiss is incorporated in this motion. So everything about Moretti and the fact that Christian Bradley did not turn this information over, and the fact that they had this Michelle Buttress, who was this over 20-year prosecutor that was telling everybody at the state attorney's office that they have to turn over this information, they have to send out this Brady notice, and she was reporting it all the way to the higher ups, and no one was doing anything about it. So that was the initial basis, but now that's incorporated into this motion, but now there's additional things, and this is the additional things that happen. The defense hired an expert, and they have their own expert to go through some of the records that were the phone records and the cell data and all that stuff, and the locations and the Google Maps. They hired their own expert to go through all this data. And this data was really received by the state according to a subpoena, pursuant to a subpoena which they served on Sprint and T-Mobile, and that's how they got these records. And then they go ahead, and of course, under Brady and under rules of discovery, the prosecutor has to go and turn over all this information to the defense. And allegedly, they did. However, this is what the defense says. While preparing for this new trial, I'm going to read it straight from the motion. While preparing for this new trial, counsel for the defendant was going through call data records and cell site location information records provided by the state in discovery. The defendant's expert, looking at the cell records, commented that the phone records alleged to be Dontavius Withers and Christopher Thomas contain notes from a third party. Specifically, the last column of information provided by the state in discovery was not that type of information that he had ever seen on similar types of records, nor were the headers what he previously encountered. So this is an expert who is very familiar with getting phone records and this data that comes along with the phone records. The cell data records and the cell site location information, he's very, very familiar with it, and he's looking at these records that the state attorney's office turned over to the defense, and he's noticing that there's a whole column here that doesn't belong. This whole column seems to have been added. And not only has the column been added, but also that there's headers, certain headers that were on top of the columns that were also seem to have been added to these documents. Then they continue in this motion. In fact, the expert was convinced that these records had been tampered. They've been tampered with. And they've been tampered with by who? Who could have possibly tampered with these records? Well, it must have been the state The state was the ones that got these records, and then they add a column and add headers. So this is what the defense says. The defense says, well, what do we do? So counsel for the defense contacted Assistant State Attorney Christine Bradley, via email and informed her that the T-Mobile true call locations and timing advanced data for the phone number ending in 9807 and the CDRs for Withers and Thomas did not appear to be original documents. So here's the defense saying, well, we contacted the prosecutor saying our expert was just reviewing this, and guess what? It doesn't appear to be original documents. So what's the response? And again, this is all from the defense's motion. So I'm not saying that this is absolutely what happened. I'm just saying that this is what the defense is alleging happened in their motion. So the defense sent this email to the prosecutor, Christine Bradley, and now Christine Bradley responds. In response to the email, Christine Bradley responded by inquiring if the drive and possession of defense counsel was corrupted. So she's saying, it seems to have been your problem. It seems like there's something corrupted with your computers or something wrong with your problem, meaning it has nothing to do with us. And then again, the next allegation in this motion, again, Attorney Liberty was one of the defense attorneys, in person informed Assistant State Attorney Bradley that she believed the cell phone records to be altered. And again, she's confronting Christine Bradley. This is in person now, and she's saying, I think that these records have been altered. In response, Assistant State Attorney Bradley stated, I gave you everything I had. You are not getting anything else. Then they continue. Subsequently, okay, they filed a motion. Okay, we'll move on from the next one. After court, on October 24th, 2023, counsel for the defendant was speaking with the assistant state attorneys trying the case at present. So now we're done with Christine Bradley and her office, and now they're talking to the new prosecutors who are doing this case, Alexandra Bukalu. And now they're talking to her, or some of the other assistants that are helping out, and this is what they say. The prosecutors for the state informed the defense that the defense must have been provided with documents that had been worked on by Miramar, not the originals. So now it seems that the new prosecutor is saying, well, from what you're saying, it appears that you did not get originals. And they must have been worked on, meaning altered, by the Miramar State Police. Remember the police department. So now you've got the new prosecutor sort of agreeing to the defense. So now what should be the remedy? So the defense says, well, one would expect that the remedy would be simply to provide the defense with the original documentation. So what's this whole big deal? Oh, let's file, we should dismiss the case now. Why should we dismiss the case? All the new prosecutor has to do is, okay, well, whatever was altered with, we'll remove, and we'll give you the original documents, whichever we received from the subpoena. Now we'll give them over to you, and then, okay, now fair game. We both have the original documents. Stop complaining. Let's move on with the trial. So the defense is saying, well, you would expect that you can simply remedy this by just simply having them turn over the original documentation. However, this is not a good remedy. However, this fails to take into account the defendant's previous trial, which, as said above, ended in a hung jury. We know before that the first trial ended up in a hung jury. Apparently, several violations occurred during the first trial. So they're saying, hold on a minute, we're not just starting over now. There was a trial in this case. And this was evidence that was presented in the first trial. And if the prosecutor is now agreeing that this evidence that they purported to be originals were really not originals and were really altered with by the state, by the police department or the detectives or by the state attorney's office, then you're going to have a real problem. So, number one, and they're going through now the different evidence that was presented during the first trial that was really had problems with it. So number one, this evidence was not in the substantially same condition as it was when it was received by Miramar Police Department. Therefore, its admissibility into evidence was improper. This should have never been admitted during the first trial. Number two, a witness testified that it was in substantially the same condition, although it was not. Which witness they're about to say. But there was a witness that actually testified that these documents are they're the same documents that we got pursuant to the subpoena. That was a witness's testimony on the stand under oath that these documents that I'm looking at with that header, with the column, was exactly the same or substantially in the same condition that they received pursuant to the subpoena. Number three, this tampered with evidence was sent back with the jury and reviewed by the jury during deliberation. So this was evidence that the jury was actually reviewing. They were reviewing those columns and they were reviewing those headers, which were added by someone. either by the prosecutor's office or the detective Moretti. That's what the defense is arguing here. The notations and alterations of the original document prejudiced the defendant as the jury viewed tampered with evidence. The jury viewed tampered with evidence. What weight and influence it had on each individual juror is impossible to know. We don't know if that affected some of the jury from not coming back with an acquittal. Who knows? Maybe some jurors would have acquitted Melly in the first trial if this evidence, these phone records, wouldn't have been altered with. They continue. Detective Moretti was the affiant of the search warrant affidavit that required the production of this material, meaning Detective Moretti was the one who got these records. The warrant listed him as the recipient of the record, so he was the one that received the record. So now they're saying, look, Detective Moretti was the one who put out the request, put out this warrant, this subpoena for this records. So therefore, he was listed as receiving these records. That means that he received the originals. Therefore, these documents were supplied to him for his review. Detective Moretti is the lead investigator in this case, and it is impossible to believe that the notations added to these documents were not done at his direction, consent, or knowledge. Obviously, anything that was tampered with must have been under his watch. Either he directed that it should be done, or he consented for it to be done, or at least he had knowledge that it was being done. These are records that were in his authority. And if he goes and now turns them over and something changed about them, obviously he was somewhat involved. This is what the argument is. Detective Moretti worked hand in hand with the prosecutor, Christine Badley. That's what has to happen in these cases, right? The prosecutor has to work together with the detective, and therefore it stretches credibility to believe that neither one of them realized that the records had been tampered with. It's very hard for them to believe that they didn't get together on this. That's what they're arguing. Further, they continue. Even without seeing these tampered with documents, the current prosecutors on the case were able to glean what had happened. Meaning without even seeing these documents, the current prosecutors, meaning Alexandra Buchel and her staff or her assistants who are helping her, they were able to understand what happened right away. They were able to figure out what happened right away. And they came to the conclusion that the defense must have received altered documents as opposed to the originals. Again, they stress it stretches credibility to believe that at the time of the defendant's first trial, the state of Florida was unaware that they had tampered with documents or evidence, and that the tampered with evidence documents were the ones that were admitted into evidence. They knew this. They absolutely knew this. That's what the defense for Melly is saying now. The prosecutor during the first trial, Christine Badley and Detective Moretti, they knew exactly what they were doing, and that's why this is such terrible misconduct. So now, they continue like this. I'm just skipping a little bit. I'm just giving you the main points. Whether it be hiding Brady material, which was in their initial motion for a dismissal, their first motion to dismiss this case was because of the Brady violations. Whether it be hiding Brady material, covering up for a lying officer, giving less than candid testimony at a hearing, providing evidence in discovery purporting to be original copies when in fact they had been tampered with, presenting that tampered with evidence to the jury, the state at each and every instance has acted in bad faith and attempted to thwart the defendant's due process rights, meaning that Melly did not have due process in this case because there's something really, really fishy going on here. So we know that Melly has due process rights under the 14th Amendment and the parallel provisions of the Florida Constitution, and therefore, this is what the defense is arguing. They're saying that this prosecutorial misconduct, again, in and of itself, but certainly in conjunction with the prosecutorial misconduct that's spelled out in the defendant's previously filed motion, meaning, so now we've got both of these problems. We've got everything that we mentioned in that first motion that we filed with Moretti soliciting this deputy to lie, and then the prosecutor not sending them a Brady notice over that before the first trial. They didn't even know about that. And now on top of that, you have these records that were tampered with. Requires this court to declare that jeopardy attached after the first trial and the charges should be dismissed. As you know, everybody understands that there's double jeopardy. You can't try the same person for the same crime twice. And therefore, since his due process, since they're arguing that his due process rights were violated, that in and of itself says that jeopardy attaches, and therefore he should not be allowed to be tried again. And this is what they quote straight from a case, as the court noted in State versus Glosson, based upon the due process provisions of Article 1, Section 9 of the Florida Constitution, we agree with Hosen and Isaacs and some other cases that governmental misconduct which violates the constitutional due process right of the defendant, regardless of the defendant's predisposition, requires dismissal of the criminal charges. So they are saying his due process rights, Melly's due process rights, were very obviously violated in this case. They didn't turn over the Brady notices, and now on top of that, they're altering with the evidence. They presented that evidence. The jury looked at that evidence and could have swayed them. So obviously, his due process rights, his 14th Amendment constitutional rights, were altered with, and therefore, the only remedy that should happen now is that this case be completely dismissed. So that is this argument. So it's a much stronger argument now than it was before, because before you just had the Brady notice violation, and now we have this other basis for dismissal. And again, it's very, very hard to achieve a dismissal in this case, but they are really making a case for this. And at this point, if this turns out all true, then they're really making a strong case for this. So again, it's going to be a very hard decision for the judge to actually dismiss this case. And it's probably unlikely, because it's just very difficult to achieve that. But they are certainly making a compelling case that it should be a consideration. Certainly, if the judge does not grant this motion to dismiss the case, it's certainly going to be subject to an appeal if they lose. So again, it just never ends with the Melly case. Just every single day is something else exciting happening. Please continue to follow if you want these updates, and subscribe if you haven't yet. Like the video so we can continue growing. Looking forward to next time. See you next time.